Okay, this is Remedies, Chapter 9, Special Issues and Equity, Part 2 of the book, Injunctions and Specific Performance, but Subpart C of this section titled Enjoining Crimes and Nuisances, page 402. The section coverage includes the following. A considerable amount of litigation has dealt with whether a court should enjoin activity which constitutes a public or private nuisance. The threshold inquiry concerns a substantive entitlement to relief. The plaintiff must establish that the defendant's conduct was a substantial and unreasonable interference with the use and enjoyment of the plaintiff's property or public interests. The court evaluates unreasonable interference by weighing the gravity of the harm against the utility of the conduct. If this standard is met, the plaintiff must further demonstrate, 1, that the threatened harm is immediate, 2, that the injury is irreparable, and 3, that no adequate remedy law exists, and 4, that equitable considerations balance in its favor. 2 factors are particularly significant in the balancing process, which is the extent to which damages will redress the injury. I'm just going to call that 5. And considerations of the nature and extent of public interest implicated, which I'll call 6, since it's not numbered. Injunctions against a nuisance are never automatic nor a matter of right. It rests within the discretion of the judge sitting in equity. An injunction case always involves some degree of future prediction. The judge must determine both the probability and degree of future threatened harm absent the injunction. The legal consequence of a particular prediction is easily applied only at the 2 extremes. Equity will not enjoin a completed act, but injunctions are granted to halt clearly continuous invasions of an important interest where the remedy at law is inadequate. Nuisance cases sometimes involve actions that also fall within the scope of criminal law. The problem then becomes whether a civil court will issue an injunction or to prohibit behavior that could be sanctioned but in a criminal justice system. The modern approach generally holds that equity will not enjoin conduct merely because it offends a criminal statute. That's the modern approach. Conversely, if the activity constitutes a public nuisance, an injunction is not automatically precluded because of potential penal sanctions. Rather, the principal inquiry involves whether an adequate remedy at law exists to address the conduct through application of the ordinary penal sanctions available through the criminal law. Related issues involve the concern that no jury trial right exists in an equity proceeding and that a civil action requires a lower standard of proof of an injunction than beyond reasonable doubt under the applicable criminal statutes. So standard of proof is an issue, and really these are threshold issues. If a remedy at law exists, so I skip the model case and I go directly into the principal case in this section, which is Harrison versus Indiana Auto Shredders Co. On page 405, Clark, Associate Justice, gave the opinion. This is an appeal from a judgment of the United States District Court for the Southern District of Indiana in a nuisance action permanently enjoining appellant Indiana Auto Shredders Company from operating its shredding plant for the recycling of automobiles in the Irish Hill section of Indianapolis, Indiana, and awarding $976,956 in compensatory and $353,912 in punitive damages to plaintiffs and interveners. This is in 1975. The suit was filed by appellee Russell Harrison, doing business as Indiana Coldwell Company, and some 33 other claimants who reside or work in the Irish Hill section, alleging that the dust, vibration, and noise generated by the company's shredding plant constituted a common law and statutory nuisance under the Indiana law. by damaging property and endangering the health and safety of residents or workers in the area, and 2, that the company's shredding plant violated various local air pollution regulations. So there's 33 other claimants. These are punitive damages and compensatory damages. All right. This case presents the very difficult question of how to balance the legitimate demands of an urban neighborhood for clean air and a comfortable environment against the utility of economic enterprise of a beneficial but polluting industry. In recent years, the abandoned and junked automobile has become recognized as one of this country's major solid waste disposal problems. Auto graveyards represent not only an aesthetic blight that mars the natural beauty of the land, but also a scandalous waste of energy and resources that produce those cars. This case is representative of a new breed of lawsuits spawned by the growing concern for cleaner air and water. The birth and burgeoning growth of environmental litigation have forced the courts into difficult situations where modern hybrids of the traditional concepts of nuisance law and equity must be fashioned. Nuisance has always been a difficult area for the courts. The conflict of precedents and the confusing theoretical foundations of nuisance led Prosser to tag the area a legal garbage can. In any case, governmental consciousness may be the saving prescript for our age. Thus, the right of environmentally aggrieved parties to obtain redress in the courts serves as a necessary and valuable supplement to legislative efforts to restore the natural ecology of our cities and countryside. Judicial involvement in solving environmental problems does, however, bring its own hazards. Balancing the interests in a modern urban society like Indianapolis may be very difficult, weighing the desire for economic and industrial strength against the need for clean and livable surroundings is not easily done, especially because of the graduations in quality as well as quantity that are involved. There is the danger that environmental problems may be inadequately treated by the piecemeal methods of litigation. It is possible that courtroom battles may be used to slow down the effective policymaking for the environment. Litigation often fails to provide sufficient opportunities for the expert analysis and broad perspective that such policymaking often requires. As difficult as environmental balancing may be, however, some forum for aggrieved parties must be made available. Excuse me. So concepts of nuisance law and equity. Traditional hybrid, modern hybrids. Okay, so this is a difficult situation. Anyhow, we haven't really got into it yet, though. As difficult as environmental balancing may be, however, some form of aggrieved parties must be made available. Some form for aggrieved parties must be made available. If necessary, the courts are qualified to perform the task. The courts are skilled at balancing the equities, a technique that traditionally has been one of the judicial functions. Courts are insulated from the lobbying that gives strong advantages to industrial polluters when they face administrative or legislative review of their operations. The local or state or federal court, because of its proximity to the individual problem, is often in a better position to judge the effect of a pollution nuisance upon a locality for these reasons. So it's got a local benefit. For all of these reasons, the balancing of the case, although difficult, was nonetheless a proper function for the court below to perform. All other forms for obtaining relief were cut off from the claimants, and they understandably turned to the courts for relief. The proximity. And there weren't any other options, so no other relief available. The problem of balancing The equities in this case, however, was compounded by the fact that the company was not the ordinary industrial polluter. Usually, industrial polluters bring only their proprietary rights to be balanced on the scale opposite the community interest in a clear environment. The polluter asked the court to give due weight to the contributions that the business enterprise makes to the community by its economic achievements, payroll, taxes, investment, or profits. Although when contrasted with the direct damage caused by uncontrolled pollution, such contributions may seem indirect. They are nonetheless entitled to serious consideration. No court should lightly decide to shut down a business that was sole or principal livelihood of the community citizens. Economic and property interests are entitled to significant weight, but here the Indiana Auto Shredders Company makes more than only these economic contributions to the Indianapolis community. It is making a direct contribution toward improving the environment and conserving its natural resources by the recycling of abandoned automobiles. In curtailing the company's operations, the court below chose a very serious course of action. It is our view that such a course of action must be based on conspicuous facts and reasonable standards of law. Environmental litigation of this type, whether based upon the Indiana nuisance statute or the common law of nuisance, logically will involve two stages of adjudication. First, the court or trier of fact will determine whether the facts alleged actually constitute a nuisance and a nuisance of what type. Second, having determined the nature of the alleged nuisance, the court will fashion relief appropriate to the equities of the case. Each of these two stages implicate their own legal standards. Some activities, occupations, or structures are so offensive at all times. Activities that eminently and dangerously threaten the public health fall into this category. It is more often the case, however, that the activities challenged by suitors in a nuisance